Hi, ladies and gentlemen. We are back with the IP Business Talks. Today we have a it sounds like a nerdy topic, but it is really impressive what happens right now. It's about court decision analysis. And obviously, it is an AI-based court decision analysis. So, an absolutely fascinating topic. And Til Bußmann-Welsch was already here. Now, this is his second time. Before I'm inviting him to come to stage, just for you, some housekeeping rules. So this is a live LinkedIn format. We are very happy to get your comments or questions in the show. That means you just write it under this chat, in this chat under this post. And I'm happy to bring that in here into the show and to ask that Til. Hi, Til. Thank you very much that you are with us today. And Til, my first question is the one which I ask all my guests, because every guest has a very interesting story how they came into this field of IP, the strange field of IP. So how did you made your way into the IP world?
Yes, Alex, first of all, thanks for having me as well. It's a great pleasure to be here again. And yes, it's a longer story how I got there. Basically, in 2015, when I started my law studies, I was in my second semester, and everyone who studies law knows it's kind of a time travel back in the past, like 100, 150 years back. But back then, we already had like a digitalization happening in the area of law, but with very, very basic concepts from nowadays perspective, with like rule-based systems. And we already had like these articles saying, okay, it's the end of lawyers, basically. And I saw, okay, it's maybe not the end of lawyers, but it's a fundamental change in how lawyers will work. And I was convinced that I want to be part of that movement, basically, back then. But of course, then I said, okay, I gotta finish my law studies first, going to be on the safe side there, but I was always triggered. And during my studies, I got to know Frederick Tolai, who was also triggered by these events and wanted to also be part of this movement to digitize the field of law. And then we sat down after our education and took like 6 months. And we said, okay, in which field do we want to go? And I started a PhD in the statistical analysis of judge behavior. And I've seen that there's a lot of empirical legal study happening in the science, the legal science area, but also in the economics. So there are a lot of companies offering database services, answering questions. How often did a specific judge name a specific argument, in which occasion, what are success rates over time, what are average damages, and so on. And we said, okay, there's like a gap for Europe, for Germany to do this. And then we said, okay, let's go there. Let's try this. And then we also said, okay, in which field of law shall we start? And then we thought, okay, we start with a field of law that is open to newer technologies and is always tackled with new developments. And that was IP law for us, with design, with patent, because these lawyers, they have to deal with clients that just develop new stuff every day. So with that, they're more open, even though law itself is conservative, but this specific field is a bit more open. And so far, it worked out. So yeah, that's how we got to IP.
And I saw on your website that already more than 500 law firms using Anita. This is a very impressive figure, I guess.
Yeah, it's true. But it's not easy to get there, of course, because if nobody knows you in the beginning, even though you have a great tool, it doesn't mean anything. So you have to get out, spread the word. And we are very happy that we convinced over 500 law firms doing it now and supporting us on a daily basis. And we are supporting them as well. And yeah, it's a great journey so far.
Okay, yeah, and I'm also very happy that you are on the platform of IPPA Connect and that you run your own Dplex website, and also that we have some blog posts with you, and also we have a podcast episode in the IP Management Voice. And for the German auditorium, we have right now a study open, and that would be great when you take the time and being part of that study. this is a very important development in usage of AI today in the legal space. So obviously, your approach can only work when you have data, right? So the AI is lost without data. So my first question is a bit around Europe. How is it there? How is the availability of judicial data, and how does that affect the development of AI systems, especially in your case, these court decision analysis?
Yeah, as you said, data is basically the basis of everything in that regard. And we see there's a fragmented landscape with regards
Okay.
to judicial data. So if we look on the European Union, we have to differentiate between different member states. And
Okay.
if we look on the more like Western countries, at least like from the perspective of Germany geographically, we see that there's like barely a lot of data available, especially looking on court decisions. For example, in Germany, we have around like 1% of court decisions made publicly available. The same.
Only 1%.
Yeah, it's like if we put it in absolute numbers, it's like 1.7 million court decisions. And if we compare this, for example, to some Eastern states like Romania started publishing more and more data, especially in 2011. And since then, they published 50 million court decisions, right?
Wow.
And if you think that Romania is like an independent democratic state bound by the rule of law beginning like in the early 19th, then it's like a very short time period where they made this possible. But Germany exists since 1949 in that regard. So
yeah,
that's a long time period, but there's a big difference. But we see in the Western states that there's a movement towards greater transparency in court decisions, and more states want to make more court data publicly available, like France, like Belgium. And Germany is also pushing in that regard, but it's a slow movement. But they also see, that's part of your second, or the second part of the question, because they see it's a basis for technological development.
absolutely.
Because if you want to have tools also supporting the justice system, enabling judges to draft faster, to look for comparable cases, to also ensure that the judges apply the law in the same way in comparable cases, so that we don't have like an imbalance. For example, in Germany, we see that in southern Germany, criminal courts tend to be stricter and a bit more harsh in ruling criminals than northern Germany. And if we would make this publicly available, maybe we could find a compromise somewhere that we don't have this hierarchy. That could be benefits for the judicial system, and the states see that and want to foster that. This is going to happen in the next.
What is the explanation why this is so different, and why? I mean, typically there is a public interest to know that decisions, right? So the population deserves to know that. This is for the understanding of law important. So what is the explanation why only 1% of the decisions are public?
Yeah. So the most important reason is just that it grew through history that way, because like 100 years ago we had like paper, and we collected important cases in paper because we said a human has to read it, so it has to be a limited amount of cases. And then which limited amount do we take? The most important cases that change the law fundamentally, and this is most of the time happening in the higher courts, the high courts basically. So we said, okay, the German Supreme Court will publish the court decisions, the Constitutional Court, and so on. And the second thing is also that you have to erase certain data out of this court decision before you make it public. Personal data, for example, data protection, but also business secrets in some cases.
Yes.
And this is human intense labor, basically. And the administration in the court said, we have so much stuff to do. We focus on a certain amount of court decisions that we want to make public. But now this changed, because of course, with the recent developments in AI and data analysis, we are able to compute big amounts of data and to get insights. As you said, I mean, you need court decisions to understand what is the law, basically. Because in Germany, we have like abstract terms in the law that you need to define, and it's the task of the courts to do this over time. And if you want to see how they do this over time, and also in the broad landscape, you need to do this data analysis to get a truly understanding. And the same is true also for the anonymization, pseudonymization process to erase certain data out of the court decisions. We have now systems to automate this process with a human in the loop still. So in the end, the human needs to take the responsibility because there's a risk of like 1% that there may be a mistake. And that we have personal sensitive data still in this court decision. But we now have resources to be faster, to go further. And as I said, there are countries already doing this in the European Union, as Romania, as France, as Belgium. So other countries will follow.
And what is with the availability of that data? I mean, I would assume when this data is done by a governmental institution or by a state's institution, like a court, so that it is then freely available, or is it even, or are there even paywalls for that kind of data?
Yeah, that's also different. So, for example, in Germany, we have over 35 databases with public data from courts. Some are run by the ministry, some are run by a court. And on top of that, of course, we have publishing companies who collect these data, like Back Online, like Juris. And Juris is an interesting part in Germany because it's a public company, or it was originally a 100% public company, and then got formally privatized. And the goal is also to privatize this company in total. But this company was formed by the state to make court decisions publicly available, basically. But in the beginning, they said, okay, who's interested in this data? It's basically lawyers, it's judges. So we put it behind a paywall and kind of get some money back for offering this service, basically. But this
so
is
a way to finance that.
Mm-hmm. Yeah, like a reimbursement. And somehow this institution got a bit independent, and because it got privatized over time, now it wants to be 100% independent. We see like a privatization of law in that area. So originally it's the duty of the state, and I'm convinced that the state should offer it for free. And that's also what Germany is striving for, that other European countries are striving for. But we still see that a lot of states relied on publishing companies, on private bodies to do this job. And the state really relied on publishing some court decisions that are crucial, still online, still for free. But like the online publishing began like in the 2000s, 2010, before you had to go in the library, basically, and look up in a book. And that's where the publishing companies kind of closed the gap, because they were earlier on offering online databases, and they went to the courts, asked for the court decisions, got them. But ironically, the state didn't publish it then in an online database for free as well. But I'm convinced that this is going to change in the future, but it's a long way still, at least for the Western states.
Yeah, and I would assume that it is a question of the efficiency of the whole judicial system to come up with that data, especially also for the work of the judges, and to get comparable cases, and as you said, development of certain terminology. So it's extremely helpful having that kind of AI support.
Yes, I'm convinced that this is the case. As you said, it's easy to find comparable cases and not to reinvent the wheel. I mean, if a judge has a case, it's very likely that a comparable case has been decided like this in the past, and then you can get some hints from that, or that you may be able to copy some parts of it and just be faster, and also harmonize the way you apply the law. Because I think for the greater public, it's not a benefit if you have one court with different chambers, and every chamber says, no, I'm ruling in that way, I'm ruling in that way. They should like organize themselves and find a way to also harmonize their ruling outside, so that you have a reliability. Basically, that's also important for the rule of law. But some days ago, I've spoken to a judge of a high court in Germany, and he said that he's afraid that if more data will get available, that we are not able to find the needle in the haystack, basically. And I think that's still this way of old thinking. I kind of understand the problem, and I see it can be a problem, but it's the technology that we have today is really able to solve these problems. For example, we can accumulate comparable cases. And if you then enter a search query in a database, you will not get 200,000 results where every case is the same, but you will just get one result saying there are 200,000 cases like this, and they are all behind kind of this one data point, but you're not flooded, right, with cases that you're not interested in. And I think
your argumentation
to trickle down in the judicial system.
Yeah, got you. So your argumentation is that it will even improve the legal system.
Yes,
using that kind of technology.
I'm convinced, because if you look back on the reason why court decisions should be publicly available, there are also in Germany high court decisions out of the 90s who say, okay, there's basically a duty of the state to make these court decisions publicly available, and it's based on several reasons. One is something that we've already talked about, is to understand the law, right? To know what are my duties, what are my rights, basically. But it's also something we also talked about, is about harmonizing the law, but it's also to control the way the law is applied by the judges. Because as a democracy, we have representatives that create laws, and then these laws are due to the separation of powers in a rule of law, then applied by courts. But if we want to check if the courts apply the laws in a way we thought of in the beginning, or if it goes in a totally different direction, and we say, okay, we need to amend something, we need to know what is happening, basically.
Yeah. Okay, got you. And so I would assume that so far we talked about the principal access to the data, but of course I would assume that because of these fragmented, so it's not just fragmented in Europe, it's even in Germany fragmented, that these data, the availability of the data has structural barriers, I would assume. And does that anyhow affect the development of your predictive model, of your AI analysis, or is it agnostic about that?
Yeah, no, it's a very fundamental problem, or it's a challenge, any way you can put it, positive or negative. And the thing is, if we have in Germany,
let's do it entrepreneurial, and we say it's a challenge.
We have, for example, in Germany, like this over 35 databases, and they all have different data formats, different metadata, for example. And it would be nice just to have, for example, one API access with the same data structure, with the same metadata.
Could you help me? What is a metadata in that context?
Yeah, for example, so we have the court decision as a text, and then we have different data that we can connect to this text that kind of explain what is happening in this text. For example, the court that ruled in this manner, the judges that were involved, the paragraphs that were cited. You can be very creative. So there could be an unlimited list of metadata. Of course, then the state has to decide what are the most important ones. Then we have to publish, and what is kind of a duty of others to find them out, basically, because the state is not obliged maybe to analyze a court decision and to extract all legal arguments, something that we do, for example, doing legal argument mining and then connecting legal argumentation over time, having argumentation chains. But it would be very nice to have like the court, the judges, the date, the norm, the paragraphs that were cited.
I got you. So what you can do with Anita is that you can create chains of argumentations through different decisions. So how does this argument evolved, and how is it used in different decisions, right?
Yeah, that's something that is possible. And for the first time, then it's possible to also challenge argumentation of judges, because a very authoritative argument, at least in Germany, is that judges say, okay, we do it that way because a lot of different courts already did it like this in the past. It's called herrschende Rechtsprechung, so ruling.
General ruling.
Yeah, general ruling. And we can now check if that's really true, basically on an empirical basis. To make this argument a bit more valid. And that's very interesting for lawyers who want to tackle a certain ruling, but of course also for scientists who just want to analyze court decision in general with regards to a different topic they have in mind. But yeah, to be able to do that, you need like a stable data source. and we have to do this all by ourselves. So we have to scrape these databases, we have to curate this data, and of course that's only Germany, and then you have the other 26 European member states where you have the same, basically. And I know that the European Commission is now going to all these member states. I also did an analysis for my PhD for all of these member states to see, okay, what is kind of the status in these countries? And the European Commission is doing the same at the moment to try maybe to harmonize it. But it's an open debate if this is going to happen, because the judicial system is not very harmonized at the moment.
Yeah. And is there a European initiative to harmonize these kind of databases, this kind of publications? I would assume that the Commission has an interest in that. For exactly that reason, which you mentioned.
Yeah, so it is that the Commission has an interest, but we have to see how far they're going with regards to concrete measures. So at the moment, we have something called European Scoreboard, where all European member states are obliged to kind of report what's the status of the publication of court decisions, which metadata do they public, what's the data format, for example. Do they have a PDF? Do they have an XML, a JSON? A JSON, for example, is better for a computer, for software to compute it as a PDF, which is basically raw text that you have to change. And they're collecting all this information just to see, okay, what's this level? And then the question is, do we want to harmonize it? And the big reason why the European Union is harmonizing is, of course, to have like a unified market. And a strong argument could be to say, okay, we want to have a unified market also for legal technology, to also support the judicial system, to have access maybe to a company coming from Spain that has a very nice service that could profit the German judicial system, but they are not able to kind of create the service because there are big barriers, because the data format is different, and they would have to scrape 35 databases, right? And maybe that would be a dream if the European Commission would create one general API with one data format that all member states support and where all member states include their data sets. Could be also interesting then for the European Commission, which is always analyzing if the member states are applying the European law and if they're implementing certain rules they're obliged to see if that's really happening or in which way it's happening in the member states. Could make this more easy also to harmonize European law in the end.
Yeah, and I could imagine that what you say is that only a selection of decisions is published. So that's a fact, and that means compared to all decisions, only a certain amount is available for analytics, for anyhow to analyze that. And so what that means is we have a data set, an underlying data set, which is per se incomplete compared to all decisions, and it is even worse, it is selective, or anyhow it could be anyhow biased. When you say, okay, this is a decision for whatever reasons I don't want to publish. I mean, that is a question to you. Is that a problem?
Yes, I think it's a problem, but the thing is we don't know how big this problem is, basically, because you can only analyze a bias in the end if you know, like, the whole context. If you know where does this data stem from, what's the data around it. But yeah, there are some theories about it. For example, there was like an investigative journalism who tried to analyze insurance law some years ago, and he had the hypothesis that insurances influence the law in a very, very strong way, because insurances pay for the seminars of lawyers and judges, and they also support the legal journals that publish in this area of insurance law, basically. And there are also a lot of court decisions available that are pro-insurances, right? So this journalist also tried to analyze, okay, is there a bias? But in the end, he could not answer this question because not all, or not a sufficient amount of court decisions is publicly available to state this, basically. So it's more a hypothesis. You cannot really say that. And there's also a different theory saying at the moment, you want to make court decisions publicly available that are special, right? And what is not special, like the general ruling. So basically at the moment, we have a lot of court decisions that are a circumvention of the general ruling. And that's also maybe an influence, right? If you just have like minority opinions that are made publicly available that are influencing then the application of law. And the third thing I want to mention in that regard is also I've spoken to the director of a big legal journal, and he said that every day he gets like 30, 40 court decisions from big law firms who sent him court decisions in a strategic way because they were positive for this law firm. And the same happens, of course, with public databases, because as a civilian or as a company, you have a right to ask a court to make a certain court decision publicly available.
Yes.
And of course, you can do this selective. You can say, okay, we won this case, so we asked to make this court decision public, and then there can be a selection bias.
Yeah. Okay, so what you're saying is that there is at least a possibility that with this publication of court decisions, that they are used strategically to have an intention to manipulate or to bias what is available in terms of also creating or supporting strategic interests of private players.
Yes. Yes, and we've seen that this happened in the past, for example, with Cum-Ex. Freshfields influenced like the legal journals before and said there's a general ruling that Cum-Ex is legal, which in the end didn't turn out very well for them. But we know that these things happen. It can always be like a conspiracy theory, so you should not say like it's always happening, but there's like a theoretical risk that it can happen. Yeah.
And I could easily imagine that a multinational company, I don't want to mention any company here, but there are companies who have a lot of issues about European competition law, for example, and also how they treat competitors, and when you then influence the publication of that kind of decisions, then you can strategically create a certain image in public with that.
Yeah. And of course, it's also, if we have this limited database for our legal analysis, of course, then also the analysis in the end can be biased, right? So that's also why we, with Anita, try to limit the data gap, basically. And we also ask lawyers to share data with us because we say we cannot wait for the judicial system, or the judicial system may be not able to do everything on its own, especially with like digitalizing old data from the past. So we say it's like a collective act, basically. Lawyers, judges work together to make more data publicly available, and to stop biases, basically.
Yeah. This is absolutely fascinating. And how is it with the different legal domains? Is that statistically equally distributed, or are there specific gaps also in the question which kind of legal field is affected from these blind spots, biases, and so on?
Yeah. I would say with regards to constitutional law, we have a lot of court decisions. So there the gap is very narrow, at least for current data. We have some gaps for old data from the 50s, 60s, because they're just in books, they're not online digitized. And also, if we look on the European patent administrations, they also make decisions publicly available, and there are a lot of decisions of them. So I think there's also like a minor gap, but a bigger gap is, for example, with regards to criminal decisions. So, and an interest for lawyers, but also for people in front of court is, of course, what is potentially coming out of this case. Is this like a fee I have to pay? Is this potentially prison? And what is especially interesting for lawyers is also because if you want to analyze the phone of a potential criminal, for example, you need an allowance by a judge, right? Yeah. And they also write like a court decision about it. And these are nearly never made publicly available. And it's very interesting to see when do they accept like something like this, or when is somebody allowed to enter the flat of someone else? What is kind of the barrier in reality? Yeah. Because we know the abstract level, the legal definition, but what is the application in reality? And I know that lawyers in Berlin, for example, collected also these decisions for themselves to analyze this. but it was too time consuming for them aside their job, so they stopped doing it. But yeah.
Yeah, got you. Okay, so it's good to hear that the European Commission has really an eye on it, and that we try to harmonize and to intensify the into the direction of making that more public, and it is obvious that this is a real problem, that that kind of data cannot be analyzed at the moment. So yeah, we have now the status quo. So what would you say? What should be done? What can be done as the next steps to improve the availability of that data?
Yeah, I think one thing is like communication between different bodies, because we have a federal system in Germany, but also in the European Union, and that is good for many reasons: separation of power and getting different ideas and kind of having a competition between different ideas. But when it comes to digitalization, it's not always like a positive effect, and we need to kind of find a compromise for certain standards. So I think it's very beneficial if we have the same data format for core decisions, the same metadata, so that everyone coming to every country can just plug and play basically with the data and develop services.
At least in Europe.
Yeah, at least in Europe. And we already have bodies that are talking about these things. But there are so many different bodies and so many different people. And, if some person gets power, he or she is always interested, of course, in keeping this power. And then maybe you have 3 or 4 projects that are developed at once. For example, with regards to pseudonymization of core decisions, we have every European member state made an own system, basically, to pseudonymize, to anonymize core decisions. And also in Germany, we have 3 systems, or more than 3 systems developed. Absolutely crazy. And this is like a communication problem, because either people are not knowing what the other one is doing, or because they say, I'm gonna do it better. I have a power position. I want to push myself in front. We have to get beyond this, right? Beyond personal egoism. And we need to get better in communication. But that's always easier said than done in the end. Yeah.
Mm-hmm. And is there an interest? So is there a kind of open data initiative or whatever that, like in other areas where there's a driving force behind such initiatives?
Yeah, there are in every country. Basically, you see that there are open data initiatives. In Germany, it's for example OpenEUR, which started in 2008, 2009 as an association to make core decisions publicly available for free. And we also had open legal data in Germany, because OpenEUR said, okay, I'm going to make the text publicly available, and open legal data said, okay, are we going to also harmonize data formats and make it accessible via an API so that companies can access this to develop services. But these are, of course, associations. So they come from the civil society, and they're dependent on individual engagement. And this can vary over time. So these associations get weaker and stronger depending on the individual engagement. And for example, open legal data basically ceased to exist because the people who built it lost the interest at a certain amount of time. So I think we cannot always just rely on the civil society. So the state has to build like a very
and that would be my next question. How are they financed? Because then there is also an interest anyhow behind that, right?
Yeah, I think that then also depends on the people running these systems. I know from OpenEUR, the founder Benjamin Bremert, he's a very reliable person, and he has an interest not to be dependent on anyone else. So he's also reluctant in like taking money like from a big company then that says, okay, we're gonna fund you, and then you're gonna publish the core decisions that we want to. That is not happening. But yeah, basically they're dependent on small funds and people donating.
Okay, got you. So it's a bit like Wikipedia, right?
Yeah. But Wikipedia has a better access to donations maybe than these small initiatives. Yeah.
Okay. But I mean, shouldn't there be just an obligation? So why can that be so complex or complicated just to make an obligation to publish these decisions? Because obviously there is a public interest to, as you said, to understand whether the law is applicated, the real application and the real decisions is made how it was intended from the government, or at the end of the institutions, the parliaments, which make the law, basically.
Yeah, and I also argued that way in my PhD, that we have a duty. I think that's also pretty clear. That's undeniable. But the question is just like, how far does this duty go, basically? And then the question is like, how many court decisions do we need from which area? Because of course, people then also say there are a lot of court decisions that don't include a reasoning, for example. And then the question is, okay, what's the interest in getting it? Because then it's just named, this case ended, it costed that amount of money, basically. And I would say, okay, we may not need these court decisions, but it's still interesting to get statistical analysis out of this. But then the state can offer like this analysis and saying, okay, in this area of law, we ended so many cases without a reasoning, basically, and it ended that and that way. But then we don't need the text itself, and then you don't need to analyze it. And that also allows then the hurdle to make more court decisions publicly available. So I think that's more the question. I think it's not the question if it's a duty, how far does this duty go, and what's the effort that we want to put into it, because the state has limited amount of money. And if you anonymize these data, you still need a human in the loop. And the question is, how much money do we want to put as a society in it to make as many court decisions as possible publicly available? And of course, then a state can also say, if we have private companies who make a profit out of it, I think it's a fair guess to say, okay, this company needs to pay for it. A civilian gets free access, basically, because it's our right as civilians to just get to know the law. But if you have a company who licenses something, then they can refinance the system. I think that could be like a working system to make a lot of publicly available.
I mean, that is how Wikipedia is arguing. So that they offer an API to these AI companies, and they have to pay for using that API. And when they just use Wikipedia as it is for free, they block them in for the data scraping, and that could, I would say, that could be a process which makes absolutely sense, and could be, as we already said, it could improve the system at all. That there is a certain obligation to pay something to get the decision public.
Yeah, and I think that's the interesting discussion. Then how do we structure this process? Because we also see that in France or Belgium, there are strong restrictions then, because they want to make a lot of court decisions publicly available, but then they say, okay, but we're afraid that people go too far in analyzing this data, for example. And France said, okay, it's illegal, for example, to analyze individual judge behavior. And Belgium said, okay, we also punish kind of this individual judge behavior, and we don't even allow like a general API access, but there's like an assembly of people who decide on who gets access. Basically, you need to apply as a journalist, as a scientist, as a company, and then they decide, okay, you have good intent, you have bad intent, so to say, you get access, you don't get access. I think then that's kind of a problematic direction.
How can you avoid that? This data is used for individual judge analysis. So that lies in the metadata then.
Yeah, for example, Romania said, we're going to include all the names of the judges in the court decisions, but in our database, it's impossible to filter with regards to the judges. So they try to implement it on a technical level, but if the names are in the court decision, then you can still extract it. So there will always be like a way around. But then, of course, if somebody finds out in France, then you're going to get a punishment, and there can be a fee up to 5 years prison. And I think nobody's interested in doing that. But I think it's a question if this is kind of a good way of treating this topic, because I can understand judges if they say we have kind of worked kind of in the dark, so to say. I don't want to start like a conspiracy theory out of this, but not a lot of data are publicly available, right? And now they're afraid that now a lot of data will be there, a lot of people looking on us, and that's also frightening, maybe also from a perspective of the rule of law, because if you think about an autocratic state, they can also use this power to better
to control it, so to speak.
Yeah. But then I think it's more like a question how we set this up, because you can also say, okay, a database is not set up by a ministry that is bound by a government, but it can also be bound to a independent court, basically. And then you hinder this. And then you can also say, if an administration uses this data to influence the judicial system, that's illegal, kind of, right? You can always set up rules. It's the question, how do we structure this? This is going to be the debate in the end.
Yeah. So we're running out of time a little bit. So my last question, we have now for 3 years these LLM possibilities available to everybody. So what would you say? How will AI change these data situation? Is that a positive influence? Is this a negative influence? And how will it be changed?
Yeah, I think first of all, we don't always need AI, of course, to get positive impacts. I think also in the judicial system, there can be a lot of improvement just by structuring different processes. But of course, AI is like one part of this kind of big mosaic that you always have to look at. And for example, it can be used for data extraction, like argument extraction, and that enables us to really see how did argumentation develop over time. We can also try to get like a hint on what could be a future court decision, like trying to predict court decisions, which is a very difficult task, because predicting the future is only possible if you have all data points that kind of influence this future. But most of the time we have, as we already talked about, like a biased data set. So you will probably just get a biased prediction. So you can just get a good guess, basically. And there are also risks in like having a self-fulfilling prophecy in the end, that you say it has been like this in the past, will be like this in the future, but law develops over time, of course. So it's this data extraction, but it's also finding comparable cases, and then making it easier to also rule in future cases, because we have cases from the past that we can rely on, not reinventing the wheel. So I think there can be very, very minor things in different occasions that just make life easier. I think that's it for lawyers and judges. Maybe they're not faster, but it makes it just more enjoying to work, I guess.
Got you. Yeah, and basically, I would say transparency is an important value in a democratic in a democratic system, and in a legal system where everybody has access to. That makes, for me, absolutely sense. So thank you very much for taking the time and to explaining us that situation. And to all of you out there, if you want to become a subject matter expert on the platform, you are kindly invited to get in contact with us, like Til, and we are happy to work with you. We are happy to promote your ideas and especially your competency, and bring that competency to the users of the IP system. Thank you very much, Til, for you and for your effort. And I promise that I will observe that very close, because it is an absolutely fascinating topic. And thank you for taking the time to come to the show. And thank you very much for having your topic, your expertise on the platform. This is really a mission critical thing. And by the way, we see that also in the access to your Dplex site, that people out there are very interested in that field. Thank you very much and have a good time.
Nice. Thanks for having me.